Mr. President, I rise today to speak in favor of Ms. Patricia Millett's nomination to the D.C. Circuit Court. As a member of the Senate Judiciary Committee, I have the opportunity to closely examine each of the judicial candidates nominated by our president. I did so with Ms. Millett, attending her nomination hearing and speaking to a wide range of the practitioners and colleagues who have direct knowledge of her professionalism and experience. Without exception, at every stage of her career, and with every personal and professional colleague with whom she's had work experience, Patty, Ms. Millett, has distinguished herself as a person of integrity, intelligence, and dedication. She is a person whose capability and devotion to a family is an inspiration to those around her. She is unanimously recommended by former living solicitors general and received the ABA's highest rating. Some of my colleagues here have argued that President Obama is trying to, quote, pack the court by nominating Ms. Millett and two other nominees to fill 3 current vacancies on the D.C. Circuit Court. These charges of court packing strike me, frankly, as without foundation. Court packing is an historical term used to describe when politicians try to change the size of a court, expand a court, in order to control its expected outcomes. That was the cause of the objection to President Roosevelt's plan to add up to 6 justices to the U.S. Supreme Court back in 1937. This is, in fact, the opposite. In fact, a current legislative proposal to strip the president's ability to fill 3 vacant seats on the D.C. Circuit could better be called court stripping. In this particular case, making nominations to vacant judicial positions is not court packing. It is a president doing his job and confirming highly qualified nominees to serve on this circuit in this vacancy would be this body doing its job. Charges of court packing, I think, are absurd on their face. They're even more absurd when put in context. Ms. Millett has been nominated to the 9th seat of the 11 authorized on this court. There are currently 3 vacancies on this vital circuit court. I held a hearing earlier this year on judicial staffing levels in my role as the chair of the subcommittee on bankruptcy in the courts of the Judiciary Committee. And I invited the chair of the Judicial Conference's Committee on Judicial Resources, Judge Timkovich, to come and testify. For those who ascribe significance to such things, Judge Timkovich was nominated by President George W. Bush to serve on the 10th Circuit Court of Appeals. George Timkovich testified, convincingly in my opinion, that the federal judiciary needs more judges, not fewer. Every other year, the Judicial Conference submits to Congress a report on recommendations on judgeships. That report did not conclude that any judgeship should be removed or remain unfilled on the D.C. Circuit. Judge Timkovich also explained why the caseload statistics used by some of our colleagues to argue that the D.C. Circuit has a low caseload and thus need not have its vacancies filled are in fact unconvincing. The D.C. Circuit, in fact, hears a unique caseload with 4 times the number of complex administrative appeals than other circuit courts around the country. You see, the D.C. Circuit is the circuit court from which all the federal agencies' actions are appealed. So more than any other court in the country, its caseload is made up of very complex, very difficult cases with far-reaching consequences and that require a great deal of time. So simply looking at the raw number of cases filed, opened, and closed is not an accurate predictor of whether or not a vacant seat on the D.C. Circuit should in fact be filled. The D.C. Circuit's caseload has in fact remained steady over the past 10 years, so the Judicial Conference has seen no reason to recommend any alteration in its staffing levels. The court packing argument made by some is also at odds with history, especially when you consider that caseloads lower than they are now on the D.C. Circuit were sufficient when all Republicans then in office voted to confirm then Judge Roberts to the 9th seat, Janice Rogers Brown to the 10th seat, Thomas Griffin to the 11th seat, and Brett Kavanaugh to the 10th seat when it became vacant. When Ms. Millett is confirmed, the D.C. Circuit will still have more pending appeals per active judge than after the confirmations of any of those 4 earlier Bush nominees I just referenced. The caseload on the D.C. Circuit would also remain above that of the current 6th Circuit and 10th Circuit, to which courts the Senate has confirmed Republican-supported judicial nominees this year. A filibuster of Ms. Millett on caseload grounds would bring the Senate to an unprecedented and regrettable place. It would destroy comity and trust at a time when our nation needs it most, when we need to demonstrate to the people of the United States that this Congress can function and that the Senate can fulfill its constitutional role. It would not just facilitate the administration of justice by our courts, but also allow us to tackle other issues. If we could move past endless and needless filibusters on issues like this, it would allow us to move forward to the broader issues of the day, tackling long-term debt and deficit challenges, the fight against global terrorism, reinvesting in our future, working together to advance manufacturing and grow our economy. There are so many other issues that call for the time of this body. With that, Mr. President, I want to urge my colleagues to look at Ms. Millett's nomination on its merits and to not be distracted by what I think are groundless arguments that this is an instance of so-called court packing by this president. This president is doing his job. He is nominating supremely qualified candidates to serve in the highest courts of this land, and this body should do its job and confirm those qualified nominees. Thank you.